Good morning, everyone. Welcome to the Planning Commission meeting. Today is October 26th, and so the Planning Commission meets the second and fourth Thursday of each month at 9 a.m. on 255 North 4th Street, Lakeport, California. The meeting room is wheelchair accessible. A request for disability-related modifications or accommodations necessary to participate in the Planning Commission meeting should be made in writing to the office assistant at least 48 hours prior to the meeting. So before we begin, can we please rise for the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. Can we get a verification of legal notice?
Everything has been properly noticed.
And moving on, we do have 4 items on the consent agenda.
Mr. Chair, I'm prepared to move that we adopt consent agenda items 4A, 4B, and 4C, and 4D en banc, unless there are changes or corrections that my colleagues would like to make to the minutes.
I just have to recuse myself from D because I wasn't present. Sorry. I have to recuse myself from item D because I wasn't present and I have not watched the video.
Well, then we should take them individually. I move that we approve the minutes from the May 25, 2023 Planning Commission hearing. Item 4A.
Second.
All in favor?
Aye.
All opposed? Motion passes.
I move that we similarly approve item 4B, minutes from June 22, 2023.
Second.
All in favor?
Aye.
All opposed? Motion passes.
I move that we approve item 4C, approving the minutes from July 13, 2023.
Second.
All in favor?
Aye.
All opposed?
Finally, I move that we approve item 4D, the minutes from September 28, 2023.
I'll second.
All in favor?
Aye.
All opposed?
Abstaining.
Motion passes. Moving on, we will have a public input where anyone can speak about any subject of concern for 3 minutes, provided that it is within the jurisdiction of the Planning Commission and is not already on today's agenda or scheduled for a future public hearing. The speakers are requested to legibly write your name on the high-end sheet on the podium and state your name for the record. If you do wish to speak for public input, we can take a moment for that. If there's anybody in the Zoom room,
Guest Tia Athene, I'm so sorry if I pronounced your name wrong. You are allowed to speak. Please state your name.
I guess we'll just, unless if I don't see any response, we're going to close public input and move on to our first item. Oh. Okay. So we are waiting for the director.
You're not obligated to wait for staff. If you would prefer to continue to the next item, it would be up to the chair as to whether or not to continue to the next item.
She said she would be here. So I think we'll proceed.
Yeah, I have a PowerPoint presentation that I can give in the meantime.
Great. All right. So moving forward, we will take our first item, consideration of proposed major use permit, UP 21-17, and mitigated negative declaration, IS 21-18, for approval of commercial cannabis cultivation consisting of 174,240 square feet of outdoor canopy located within 196,020 square feet of cultivation area for Ziegler Springs North, Brian Pensack, located at 11615 and 11625 Ziegler Springs North Road in Kelseyville. The APMs are 115-007-03 and 115-007-06.
Good morning, Commissioners. Thank you. Okay. My name is Trish Turner, and I will be presenting this PowerPoint presentation. I'm an assistant planner with the Community Development Department of Lake County. We are presenting for major use permit UP 21-17 and initial study IS 21-18 for Ziegler Springs North. The applicants are present and available along with their consultant. Today we'll be talking about the permit request, the project scope, the site description, the project analysis, aspects of interest, cumulative impacts, and the recommendations. The permit request is the applicant is seeking for 4 acres of outdoor commercial cannabis cultivation with a self-distribution license. This is the vicinity map located, the 2 stars are the 2 parcels in question. The property is around, give or take, 5 miles from southwest of Lower Lake and about 2.5 miles northeast of Cobb, accessed via a central driveway off of Ziegler Springs North. The project zoning is the general plan designation is resource conservation. The base zoning district is Timberland Preserve District, and it has a special lot size density, which is B3 for 80 acres. It is located in the Cobb Mountain Area Plan. Parcels in the vicinity are zoned rural lands, rural residential agriculture, and the surrounding uses are rural residential dwellings, agriculture uses, and some cannabis uses as well. The site sits on over 80 acres combined with the 2 parcels, mostly undeveloped, except there is a PG&E utility easement. It has an existing well, an entry gate, and an access road. The scope of the project is 174,240 square feet of cultivation cannabis area with a 196,020 square feet of cultivation area total. They are proposing an ADA compliant portable restroom, a 15-foot by 15-foot trash enclosure, 2 80-foot by 40-foot permanent shipping containers, 5 2,500-gallon water storage tanks, a 40-foot by 20-foot compost area, a 5,000-gallon water storage tank for fire suppression system, 22 seasonal hoop houses that would be permitted under the new ag-exempt building permits, and perimeter fencing. Our project analysis, the regulations reviewed for compliance were the Lake County General Plan, the Middletown Community Area Plan, Lake County Zoning Ordinance, and state regulations. The Lake County General Plan, this is in compliance with Chapter 3, Land Use, and Chapter 11, Water Resources. The project analysis was done for the Cobb Mountain Area Plan, and 3.9 in our Cobb Mountain Area Plan describes cultural resources, and it requires that the applicant provide an archaeological survey, so that way they can make sure that they're not going to destroy or affect any cultural resources, and the applicant did provide that. Also, fire hazard, the applicant will provide a 5,000-gallon water tank dedicated to fire suppression, and all water tanks on the property will have the necessary hose attachments to support firefighting equipment. The Lake County Zoning Ordinance, Article 6, which is Timberland Preserved Zoning District, Article 30, which is the special lot size that has the attachment, and Article 27, which is has the cannabis ordinance as well. There are no current conflicts with Chapter 21 of the Muni Code or with Chapter 27, the zoning ordinance, and it is in compliance with the base zoning. The project analysis, as you can see, it could cause an impact to the, all of the aesthetics, air quality, biological resources, all of those named up there. The initial study and the mitigated negative declaration identified potential significant impacts in the following categories. Mitigation measures were added to reduce impacts to less than significant. The aspects of interest is water use. That's always an aspect of interest with any cannabis cultivation project. The project proposes using 6.6 acre-feet of water per year. The well yielded was estimated at 40 gallons per minute with a 2-hour well yield test. Ordinance 3106 requires that a hydrology report and a drought management plan to be submitted. Those were submitted to our department June 29th of 2022. Revised documents were submitted May of this year of 2023. During circulation, initial study mitigated negative declaration. Our staff reached out to the California Department of Water Resources, the State Water Resources Control Board, the State Water Resources Control Board Division of Water Rights, and Central Valley Regional Water Control Board. With note, we didn't receive any adverse comments. Aspects of interest is that there are several dead and dying trees located on this property. Some of this property was burned in the Valley Fire, which left several dead trees. Some trees are standing or dead, and those create a hazard as well, and so some of those trees will be removed. Our cumulative impacts. There is a typo on this screen that says UP 21-13. It is in the correct location. It is though UP 21-17. Within 1 mile, there are 6 approved projects. However, 3 of which of those are currently not cultivating and have opted out the last 2 years. The recommendations is we recommend that you adopt the mitigated negative declaration, initial study IS 21-18 for use permit 21-17 with findings found in the staff report. And that you approve the use permit UP 21-17 with the proposed conditions of approval and with the findings found in the staff report. Any questions or comments?
Yeah, just really quickly, back to that cumulative impact.
Do you want to go back to that map?
Yeah, radius. You stated that the blue or the lighter blue were projects that were no longer active.
There's 6 that are within 1 mile of UP 21-17, but of those 6, 3 of them have opted out of growing.
Okay, 3 of them have.
For the last 2 years. I don't know if they're going to do it in the future, but as it sits today, 3 of those 6 have opted out.
Okay, thank you.
I have no questions at this time.
I also had another question regarding the grading activities. I didn't really hear much on the staff report regarding that. I guess more in detail. But one of their reports stated that the trees will be removed in the area will be graded flat. Throughout reading, I did find that in vegetation, about 128,000 square feet and 40 small trees will be removed. Do you know the species or anyone from the applicant can maybe give us those answers, like what kind of trees will be removed? And by small trees, what does small trees mean?
Good morning, Richard Knoll, representing the applicant. The site is kind of a mixed forest with gray pine and some oak trees, and most of the trees are relatively small. Many have been burnt or were burnt in the Valley Fire in 2017. 40 trees may or may not be removed. That number is probably somewhat high. The area is actually not heavily wooded. There's a lot of standing dead. And as far as grading, it's actually a relatively level site. There may be grading or there may be, very little grading depending on the cultivation method that is used. If, for example, grow bags are used, those can be placed right on the surface with some basic grubbing. So we will be required to prepare and submit a grading plan to the county.
Okay.
I'd like to ask specifically, will any trees greater than 6 inches in diameter at breast height be removed?
Some may, yes.
Like how many?
I don't know the specific answer to that question.
May I follow up on that? Morning, Richard.
Morning.
Normally, when there's meaningful tree removal involved, there's an attached report from an arborist or expert who, in this case, has made a determination about trees that may or may not be cut down and how many of what size, diameter at breast, that kind of thing.
Yeah, I don't think that was required of this project. I'll double check the file to see if, do you recall, Brian, if there was a tree report? I don't recall.
It's just, it sounds a bit vague to me in terms of numbers and size of trees and numbers of
I think-
mature oaks, that kind of thing.
I think the reason is because the site was impacted so heavily by the Valley Fire.
Then perhaps an expert should assess that and make a recommendation.
Yeah, I'd like to agree with John. I'm not ready to proceed without knowing specifically.
So also another mention of a complex grading permit, yet we're being told that the site is fairly flat, I think under 10 degrees for most of the cultivation area. So will a complex grading permit be required or will it not? We're not clear as of now or based on the report if how the cultivation is going to happen. Is it going to be in the ground? Is it going to be on smart pots? Also, I didn't see on the on the plan the 22 hoop houses and what their layout will be. We do just have an open, just the cultivation area is going to be within these parameters, but not an exact for the hoop houses. They are temporary or seasonal, but I guess I kind of would like to see how that would look within the cultivation area.
I have a question for, I think this would be more staff-directed. The attorney for the opponents of the application point out that there is no reference whatsoever to exclusion zones or areas in the staff reported materials, and I couldn't find any specific references. And so I'm not clear whether there is, in fact, on the area maps that we've seen, if there is intrusion into an exclusion zone or not.
The exclusion zones were actually a part of Article 72, which is no longer in our zoning ordinance. And Article 27 now has what the exclusion zones are. And the GIS that is used is not updated to what those exclusion zones are. Water districts are no longer a part of exclusion zones.
The Board of Supervisors, after they made that exclusion zone, revisited it shortly after that and removed it from the exclusion zone, but made the rule that cannabis permit could not access public or municipal water sources. So they did that because there was a project down in Lower Lake that was within one of the public water districts but was not using the water, and that's what that was pretty much the basis on why they fine-tuned that rule. So the reference to the water district is no longer applicable.
Thank you.
I have a bunch of questions. First of all, the big one is the water. Obviously, the hydrology report is saying this project's going to need 12,000 gallons per day. That equates to 2,000 plants. We're talking about 22 greenhouses. That's 91 plants per greenhouse.
Hoop houses.
Hoop houses. Can you articulate the difference for me?
A greenhouse is a permanent structure that has different layers and they can have fans, doors, electricity. Hoop houses are just made out of sometimes just PVC pipe and clear plastic.
Okay, and
It
so
doesn't
they don't have-
support. It doesn't support electricity. It doesn't support lights. It doesn't have the automated rollovers, things like that.
Okay, thank you. So I'm just curious, is this accurate? I mean, are we really talking about just 2,000 plants?
Talking about 4 acres.
Okay, that comes out to a lot more than 2,000 plants. Can we maybe get an answer from the applicant about this?
What's the question?
How many plants? No, I understand. How many plants are we talking about in total, 4 acres?
I would have to confirm that. I don't have an answer for you right here. So let me do a little bit of research on that.
Okay. Let's go on to the access issue. I'm not a lawyer, and I was really confused by the dates. Did somebody take a close look at that and figure out whether these people have an access easement or not?
The the easement deed was actually uploaded as an attachment to address that issue. It was a recorded document, and
Yeah, but the date, what I'm concerned about, and I read it, were the dates. One of them was in January of 1993, and then another one was made in October of 93, and then another one later after I'm confused. It sounded like the easement was already signed off to somebody else in 1993, and so in 1994, would they have the right to do that again? I mean, I'm just confused about it.
May I build on that question, if my colleague permits? We received at the 11th hour, which is typical, a response to one attorney's point of view on the easement versus the other. And I'm not an attorney, and I'm wondering if council has looked at both of those responses and can provide some clarification as to the existence of an easement or not.
County Council also, like your commission, received both those letters this morning, just prior to the meeting, hasn't had a chance to review them. However, generally speaking, I can tell you that our office is not in a position to be able to determine whether or not an easement is legally valid. We can look to see if the documents and all the appropriate documents have been filed and that the criteria for creating an easement is there. But whether or not it's a valid easement and whether or not is a private issue, the dominant and the subservient tenements would have to, the owners of those would have to argue about that and have a court determine whether or not it was a legally valid easement. However, your commission can take into consideration any evidence presented to you, and if you have concerns, you can certainly ask for clarification. If you, based on the evidence presented to you today, if you determine that there is not, you can deny based on not having access, and if you determine that there is, based on the evidence in front of you, enough evidence to determine that there is access to the property, then you can certainly approve. And again, if you're not sure, you can ask for clarification.
Thank you. This is now 3 issues that are significant to me, and I'm going to probably make a motion to continue for that reason. But since we're all here today, I'd like to bring up a couple other issues as well. We received...
Mr. Chair, I'm sorry to interrupt, but regarding the access easement issue, could we, I just wanted to mention that our attorney is on Zoom and can provide some input if you'd like to just hear about that particular issue before moving on. Sorry.
Yeah, I'd leave that up to the chair, but I'd like to digest all this stuff that we've received first anyway. So I've read all of the input that was provided up till 8 o'clock this morning, but there have been 8 more comments since then. And I'd like to look at them all. So if I can just proceed, one of the issues that was brought up by a member of the community was the proximity of a church. And I believe in the past, that's been a problem, a place where children gather or something. I'd like clarity on that issue. And then somebody else, I think it was Timothy Toy, brought up the issue of a well that was not considered in the hydrology report.
So the spiritual sanctuary, the actual facility is 1.4 driving miles away from this particular property, and it is 0.98 air miles away. So it doesn't, the spiritual center does own the neighboring property with the question of easement, but the actual facility is 1.4 driving miles from the cannabis cultivation.
Okay. All right, thank you. I think there was something else as well, but I'd like to review my notes and I can let other people talk while I do that.
So I just have one last comment, or it might be a question. Then we'll open up to public input so we can get some of those answers. Under proposed project, it says cultivate outdoor full sun or in temporary hoop houses using light deprivation with cultivation period of 150 to 180 days. I guess what I'm trying to ask is it going to be outdoor, or is it going to be in hoop houses, or is it going to be half and half? I'm just looking for kind of what are the activities, proposed activities, because I'm kind of getting trees will be removed, trees will not be removed, some will, some may not, some grading will happen, some might not. So I guess this is another one of those. I guess just a clarification on the actual proposed project and cultivation activities.
So whenever this project was submitted to our department, at that time, DCC regulations stated that any hoop house structures would be light deprivation whenever they control the light. However, DCC did change their view on that, and our county Board of Supervisors has adopted that they're going to follow that, and the hoop houses are no longer considered light deprivation. They are considered outdoor as long as they are not using any artificial light.
But yet, I would still like to see kind of what that layout would look like within this cultivation, and potentially how many plants we're talking about there, because are they going to be, 1 foot apart and just fill the whole area with hoop houses? And that's going to be their practice because it might be more efficient, or is it going to be outdoor?
Okay.
I guess I just want to know what that layout will look like.
Okay. And they did submit grading plans to our division. I just guess I failed to put them in the attachments.
Okay.
Thank you. I found one more question in my notes, and that is somebody brought up that this applicant has been in violation before, and are we allowed to consider that? I'm looking at Nicole.
I don't know.
Yes, your commission is allowed to consider that. There are also some rules that relate to repeat offenders if there are actual code actions. I don't know what violation this may be, if it is in fact a violation, or if it's someone claiming a violation for the first time, I don't know. But if there were past code enforcement actions, for example, you could certainly take that into consideration.
Yeah, thank you. If it's appropriate, I would ask Director Turner to direct staff to explore that. I'd like to know exactly what went down.
Duly noted.
And I will point out, commissioners, that asking, it is one of the findings that there are no current violations, because the code prohibits the issuance of a permit if there are actual violations currently existing.
Any more questions from the commission before we open up for public comment? Unless if you have another question? No? All right, so we will be opening public comment. Each person is allowed to speak for 3 minutes. And I guess we'll get some of these questions that the commission has answered.
Just a point of order. Does that 3-minute limitation apply to the applicant?
If we're getting these questions answered, I think we can give you more time on that. I guess it's more of if people want to, comment on the project in support or against the project and the reasoning behind it. But we do have a lot of questions that the commission has asked, so we'll let you answer those.
Commissioners, if I may briefly, in the past, it is of course up to the chair who is the individual running the meeting at the time, but in the past, the commission has allowed the applicant and applicant representatives to come up and sit down and speak more on their project than perhaps public commenters would.
I would be comfortable with that, Mr. Chair. Sure. Mr. Knoll often has a PowerPoint presentation or something that supplement his comments.
I do not have a PowerPoint today, but I would like to express some opening remarks on behalf of the applicant. My name is Richard Knoll. I'm a planning consultant located here in Lakeport, and I am representing the applicant here today, and we have in the audience Brian Pensack and Garrett Burdick, who are here or can answer additional questions. I would like to start with kind of an objection concerning the issue relative to the comments about violations. There are no violations concerning this piece of property. And the fact that that issue was brought up having to do with a completely different project that has been fully resolved and dealt with, I think frankly is out of order and should not have happened. And it is not germane to this application in really any way, shape, or form, particularly since the violation that is referenced has been resolved.
If I can just jump in there, I think that's valid, but I think it was brought up by a member of the community, and I think the community is allowed to say whatever they want. So, but I
Well,
hear
it
you.
hasn't been brought up here.
Yeah, that's why we're bringing it up, because I'd like to know, and so I hear you.
Would like to go through the presentation. And by the way, our attorney is on Zoom. He may want to weigh in on this matter as well. We also have, his name is Brad Johnson. And we also have on Zoom Dr. Angie Dodd, who is the project engineer and hydrologist. They are both available, and I think will want to provide some input concerning this project. The project was actually submitted to the county in April of 2021. I want to thank staff and the commission for your consideration and work on the project. Our application was deemed complete. We have provided staff and the commission with the full range of what is required in the zoning ordinance with respect to these types of use permit applications. And as you all know, it's an extensive amount of background detail and information required, including the application form, project description, property management plan, cultural resources report, biological report. We've provided site management plan with BMPs concerning stormwater runoff, site plans, the groundwater hydrology report, and as it turns out, there is a tree report. I wasn't involved in the project over the entire time frame. I was not aware that a tree report was produced. I don't know if it was provided to the county. It's dated July 2022, done by Jacob Zune foresters. I think they're out of Ukiah. I've seen some of their work on other projects. But that is available for consideration by the Planning Commission. So we are aware of the fact that there is considerable input, public input, that has been provided to the Planning Commission. I looked last night, there were 29 emails. I've gone through those 29, but I understand we're up over 50 now. To me, that represents an organized and directed kind of effort. We certainly appreciate and understand the public input component to the land use process. We respect that. We would like the opportunity to come back up at some point and address those specific comments. I don't know if now is the time to do that, so I will not really embark upon that. But suffice to say, we have a lot of input and response that we'd like to give, and would like the opportunity to do that. So I think staff has done a good job describing the project, and we're available to answer any questions or respond to additional matters. Again, I'd like to introduce Brad Johnson and Dr. Angie Dodd as additional consultants on this project and defer to them at this point.
Thank you. So from those two representatives, could we get the question answered as to what are the actual proposed project activities and layout of those hoop houses?
Well, it's an outdoor project, and the county considers the use of hoop houses without any power, artificial lighting as an outdoor activity. It may be defined as light deprivation when blackout covers are pulled at various times, but it is an outdoor use, an outdoor cultivation method. The use of the hoop houses is subject to the application for, I guess, an exempt building permit with also an associated demolition permit. So you have to do that every year. You have to apply and then take them down. And so that is the intent. I have not seen a site plan. There may be one that identifies the location of those hoop houses, but in theory, the entire 4-acre cultivation area could be used for hoop houses because it is an outdoor cannabis cultivation method.
Mm-hmm. So it will be taken down every year?
Correct. That's what the county requires for the use of these exempt hoop house. Again, no lighting, no mechanical, no fans, that kind of thing. So if need be, we can provide a detail regarding the hoop house layout.
Sure. Yeah, I think it would be useful just to kind of see what that would look like. Yeah.
If I might also add to that, Ordinance 3132 that was adopted recently by the Board of Supervisors, regulating these ag-exempt temporary hoop houses for cannabis cultivation. It is required that the hoop houses be located within the already studied cultivation area, There are also requirements regarding their maximum height, their length, their width, a minimum of 3 feet in between structures for access or for egress, and a number of other regulations. So regardless of within that, there is, the ability for each permittee to decide their own layout, but this is our minimum health and safety standards, and it will comply to that.
And the 40 by 100 is within those parameters?
It has a maximum length of 150 feet, requires exits at both ends so that there's never more than 75 feet distance from an exit. 36-inch wide path of travel to each exit as well. Distance, yeah. Sorry, did I answer your question?
I'm more worried about not much as the length, more of the width.
Width.
At 40 foot. Wow.
Maximum width, 20 feet.
Maximum width.
20 feet.
20 feet per
Yes,
per hoop house, right?
correct.
So here we have 22 of 40 by 100, so I guess those would just be cut in half.
It would be modified to meet our regulatory standards.
Okay.
Yeah, it is likely that this staff report and the ordinance sort of passed in the night.
Oh, okay,
And
gotcha.
So, yeah, but going forward, the permittee would be required to adhere to, if they wanted the ag exempt hoop house. There are options for, if you don't want to pursue the ag exempt permit, then it would be building permits.
Okay.
Yeah.
Thank you. Yeah, I just wanted to just clarify that because the sizes seemed, I was just wondering how it's gonna look, and for that reason, that is why I asked for the layout, just to make sure of that.
Thank you.
Okay, thank you.
And for me to evaluate this effectively, I think what I'd really like to know, Mr. Knoll, is the number of plants, and I'd like to see some science on how much we can expect those plants to consume daily. Hoop houses are going to reduce the evapotranspiration of the plants, clearly, and most of these hydrology reports refer to a study of outdoor. So as our target moves, we kind of have to, I think, reevaluate these things, because we're calling it outdoor, but it's not going to consume as much water as an outdoor grow. So, thanks.
Not a question for Richard.
I'm sorry. I just want to remind the chair that we have Dr. Dodd and Mr. Johnson on Zoom, and they are part of this presentation. So I think they might be able to answer the question.
Mr. Chair.
Thank you.
Yeah. Well, I'm delighted to know that there is a tree removal report that exists, and it's something I'd like to digest. And I say that because we have literally brought down applications due to tree-related issues and nothing else. And so I consider that important, and it may incline me to support my colleagues' move to continue. But I do know Dr. Dodd, and I do have a hydrology report question to bring her in from the Zoom room. And the opponent's attorney criticized the fact that the wells on Holy Domain's property were not quantified or metered or checked themselves. My understanding is that a hydrology report typically doesn't go onto the owner's land and count wells, and assessments were made, and it sounds like they identified 4 wells that were in the vicinity, the nearest one 320 feet. But we don't know much about the water use of holy domains, et cetera. So I'm wondering if Dr. Dodd could address that.
You are now allowed to speak. Please state your name.
My name is Angie Dodd. I'm with North Point Consulting Group. Good morning, everyone. Question regarding the Holy Domain wells. They are over a mile away. And so we typically, when we do these hydrology reports, and I've been looking at the ones done by other consulting firms, a mile away is usually outside of the impact area range. There are a few wells in the vicinity of this project. The other thing I want to say about the Holy Domain, they're a whole different geologic area. If you look at the geologic map of the site, which was included in the hydrology report, we're in a different a kind of aquifer storage area. There are wells within the vicinity, but typically the impact due to the transmissivity, that radius of influence is low and under that 300 feet mark. So the cumulative impact is pretty low. Also, with almost every recommendation that is made in the hydrology reports that I prepare, I always recommend spring and fall monitoring to make sure that aquifer is recharging and adjusting cultivation accordingly. These, even though a lot of folks do not consider these agricultural or don't consider cannabis an agricultural commodity or product, it is an agricultural activity. And if, all folks that cultivate any kind of crop, it's dependent on the amount of water available. I've demonstrated that there is sufficient water to meet this low demand. When you talk about the number of plants per acre, you can look at this multiple ways. 500 may seem low, but if you have a higher density of plants, they're smaller, they consume less water. Using, the standard of 3,000 gallons per day per acre is used throughout the analyses on these projects. It's the standard in multiple counties. The quantity that is used per plant is a very high estimate. So we can assume double the plants and then not be so conservative on the demand per plant. So this 3,000 gallons per day per acre is a standard. And the cultivation period that's used is 180 days, which is typically a longer cultivation period. And then over that cultivation period, at the beginning, you're going to have a lot less use. And at the end, as the plants mature, you're going to have a lot less use. So it's higher in the middle. So again, there's a lot of conservativeness built into that 3,000 gallons per acre per day over that 180 days. The other thing, and then I'll answer questions if you have them. I'm trying not to speak too fast. The other thing about this project, there is a less than 3 acre conversion application. I think it was submitted to CAL FIRE and the forester conducted a survey on site. This project has been at the planning department since 2021. It's been through multiple planners, multiple files. I'm not sure, where the forester's report is, but the majority, I think every single tree is small. There's not one tree in the report above 30 inches DBH. The majority are under 10 inches measured at breast height, and a lot are under 6 inches. And then a lot of the trees were burned, damaged, dead, and dying. I'm not a forester, but that information, if the planning department does not have it in their file, can be provided to their file that this less than 3 acre conversion has been applied for, or I think it's required in the initial study. Not sure, I'd have to look at that. Maybe Trish can speak to that. The other thing I wanted to point out, over the last, 2 years since 2021, we've submitted numerous material requests to the county. The hoop house or hoop structure design was, as Mireya said, prior to the hoop structure ordinance being approved, so that can easily be modified to address the sizes that are in that temporary hoop structure ag ordinance. I think I've addressed everything. There are a lot of information brought up, but again, I'm here if you have any questions.
Thank you for that. I was really just trying to get more to the point of cumulative impacts in terms of water use. And I noticed that the hydrology report looked at 4 wells, including one that was 320 feet away from Holy Domain's well or property. And I'm just wondering if any of those other wells that were involved or referred to in the report are used by Holy Domains.
Yeah, that would be, Holy Domain would have to answer to which wells are their well use. Cumulative impact, the one thing that I do want to point out, when the quantification of recharge is done, was done for this project, it was based not on the full recharge area that we've estimated. It was just the project parcel area. So it's the parcel area's contribution to its own recharge. So it's what the parcel would generate itself. So I just want to make that clear. And then I did try to quantify the aquifer that the well is drawing from and the estimated groundwater storage. The wells throughout are very prolific, and it does have, the estimated storage is about 5,000 acre feet. And this well represents, the use on this project is about 6.6 acre feet per year. That storage, was 5,000 acre feet per year, or a total of 5,000 acre feet. I apologize. And the project's estimate of use is 6.6 acre feet per year. So quite small compared to that overall storage of the aquifer. And then with monitoring demonstrating that the well's capacity is recharging every year, then, we can make the conclusion that there will be no cumulative impacts associated with this project.
Thank you. I'll ask the attorney for the opponents of the plan about if those wells are used or not by Holy Domains.
Okay, were there any other questions for me?
I believe those are all the questions for now.
Okay.
So we will go back to public comment, see if anybody wishes to speak.
Good morning, Commissioners. My name is George MacDonald. I'm an attorney for the opponent, Holy Domains. Good morning. So I'll address some of the questions here and point out some other aspects of Article 27 as well that applies. So first, concerning violations, it is a proper aspect to consider in this case. Article 27, the portion dealing with individual fitness, right? The fitness of the actual applicant individual is not limited to this property. It talks about background checks. It talks about prior convictions, and it talks about any violations of Article 27. It's not limited to this project. So that is proper to consider, as my understanding County Council has the same position on that. I'm not going to go into what those violations were. I did review the prior supervisor meeting with Lake Vista Farms in Clear Lake. The violations were considerable and serious. I'm not going to go into what they were. I'll let the commissioners and county do their own research on that. The second aspect of it about the exclusion zone. We reached out to the county months ago about the application of the exclusion zone to this project and received no response, essentially. We weren't told that there was no exclusion zone. We were told basically there's no policy on it. Now, I understand that Article 27 does not have the public water aspect of it. However, it does have the church aspect of it. Holy Domains is a church. The parcels directly south and east of this project are owned by a church. They're sanctuary parcels. Quite recently, we went, when Ms. Grant was still county council, we went with her to establish that those are part of the religious sanctuary, those parcels for taxation purposes. There's Supreme Court cases, United States and California Supreme Court cases directly on point, establishing that if parcels, even vacant land, are used by a church for religious purposes, they are part of the church. So the exclusion zone and area should apply. It says it right there in Article 27, that specifically it's specifically subsection H of the commercial cannabis cultivation exclusion areas. It points out church. This church also has minors involved. That's the point of the exclusion area. Okay, so it should apply. It hasn't been reviewed. Obviously, there's no mention of it anywhere in the application materials. This should be reviewed and thoroughly discussed. I'm going to discuss access. I haven't seen Mr. Johnson's letter or what his point of view of it is. However, the fact is, James Philip Garris, he did not own the property when he signed the easement. That's shown by the documents, the recorded documents. Maybe there's some other documents we're not aware of. Mr. Johnson, I'm sure, will comment on that. He'll probably say easements run with the land, whether or not they're in the legal description or not. However, they must still be granted by someone who owns the property in the first place. Mr. Garris did not own the property. It was deeded from him to a different individual, Lucille, and then he granted the easement, and then Lucille deeded it back to him. Why did that happen? We don't know. However, that's the fact of the matter. That's what happened. We can't rewind history and now say, well, he may have owned it, he may have been entitled to do it. He wasn't. We go based off what the record shows. In court, that is even admissible evidence subject to judicial notice, and I think it's proper to consider here as well. So there's really no rewinding that. It's not in the legal description of any of these properties. Usually that occurs because the title insurance company will not insure it. So the title insurance company themselves will remove it from the legal description saying, we cannot verify that this is a valid deeded easement. We cannot insure it. It's removed from the legal description. I can probably guarantee the applicant has a title report from when they purchased this property. It'd be interesting to see what it says on that aspect and what the title insurance company has already found about it, right? I'm not a title insurance company. I'm not an underwriter. I'm just reviewing what the record says and making conclusions from there. However, there are experts available to provide things as guarantees of an easement. That exists. It costs about $500 to do. And maybe they should do that if they're claiming that this is an easement that is valid. Have a title insurance company guarantee that it is. Now about the hydrology report. I submitted a letter, I hope you all have it in your materials here, and I included as tab 6 actually showing the exclusion area that's shown on the GIS. If you look at tab 6, however, in the parcel 115-01503, which is owned by Holy Domains as part of their religious sanctuary, it's part of the church, there's a small square parcel within that. That is a well. It's directly south of this property, I believe less than 1,000 feet from this property where the project site is. It was not analyzed. And Commissioner Hess, you're right, they probably wouldn't know it's there, but they didn't ask either. And that's a big pervasive problem in this project. There's been zero communication from this applicant with the actual community members. They're planning to create quite a massive project here, a lot of plants. We don't know how many, but a lot, right? It's going to be probably more like 20,000 in the end, based on the area of cultivation. They didn't ask what the needs of this community are. There's a large residential community there. They didn't ask, no communication whatsoever. They didn't say, well, where are your wells? How would they be affected? No communication. And I'll point out, this project site is on the top of a hill, on the top of a mountain. Water flows downhill. All of the wells studied in the hydrology report are uphill from where the project site is. None of the wells downhill have been studied at all. That's a serious issue. And I know that's something that in the past, the Board of Supervisors has questioned the sufficiency of a hydrology report where it only measures and reports on wells that are uphill, not downhill. I'm sure that Holy Domains will cooperate with providing data. At least one of their wells is metered, and that data is available. I think it's actually reported to the state and should be easily accessible. So that should be, it's another concern that they have. My understanding is some of these wells are already going dry. There's 6 other projects in the immediate vicinity. The cumulative impact of those projects has not been analyzed. And getting to the communication aspect, again, the project purports that across Holy Domain sanctuary property, they're going to construct a road. The road will need to be paved. The road will need to have fire turnouts, 4290 compliant. The road will need to have culverts across their sanctuary property. They've never asked if they could do this or not. It's not clear that they can do it when it's a tax-exempt sanctuary property used for religious purposes. Yes, this might be a private issue that will be fought in court, but I don't think that this should be required to go to court. This should be resolved before then. Thank you. I'm happy to answer any more questions that there are, and I thank you all for your time and consideration.
Thank you.
Commissioners, I'd like to provide a correction. County Council does not agree about the assessment of Article 51 related to the findings about violations. Article 51, Section 51.46, which is where you find that finding. Criteria does in fact say that that no violation of the listed chapters of the county code currently exists on the property. And it provides an exception for violations that are off of the project site. So it would not encompass every violation related to the individual or the entity that is applying for the permit. It would be related to this particular property and project site.
I'd like to clarify, I'm talking about Article 27, subsection H, qualifications for a minor or major use permit specific to cannabis. And then H1, failure to comply with the provisions of this chapter. We're talking about Article 27 chapter. And then it goes on, subsection 3, the applicant or owner or permittee has been convicted of an offense. So it's not specific to the property at all. It's talking about the personal physical characteristics and personal fitness of this individual applicant. That's what we're asking about. What is their history? What is their past? Should they be granted a permit to grow however many thousands of cannabis plants in a community? That's what we're asking.
Hi, do we have the timer set? Okay, cool. Sir, you will have 3 minutes. Please state your first and last name for the record.
My name is Timothy Toy. I've been selling real estate in the Cobb Mountain area for the last 30 years, and I own a number of properties in the area. There's been numerous examples in my time selling real estate where I've encountered individuals who have suffered from a falling water table in Lake County. So this is something that has to be taken very seriously if we are to protect the rights of the citizens of Lake County. Here's an example. About a mile away from the project is Salmina Meadow. Salmina Meadow is the headwaters of Coal Creek. Coal Creek is a year-round creek that flows into Clear Lake. I own a property about another couple of miles down from the headwaters of Coal Creek. About 3, 4, 5 years ago, Coal Creek, which had always run all year round, started to puddle. At the same time, the tenants in my house there, and the well had been used for 50 years without interruption, just suddenly dried up. It cost me $15,000 to put in a new well that I felt was a involuntary subsidy that I had to pay to the vineyard and cannabis industry in Lake County. So, and I understand that Coal Creek doesn't even in the summer reach Clear Lake anymore, which brings up the issue of the Clear Lake hitch, for example. So the commissioners, the planning staff of Lake County have to be very careful about approving projects that directly impact the use of water for all the residents. And speaking to that, even today, there's a vagueness about how many plants. Here they are. The applicant has been working for a couple of years, apparently, and we still don't know how many plants they're trying to put in. Is it 1,200? Is it 2,000? I mentioned the matter of 22 hoop houses proposed for 4,000 square feet each. That's 88,000 square feet. This woman was a consultant to the cannabis industry. She said they're fibbing, probably 20,000. If you go up the road about half a mile, there's the Pasta Farms outdoor grow. It's about 13 acres, I believe, and they're between 8,000 and 10,000 per acre. So do the math. The hydrology report is based on 2,000 plants. It doesn't study the watershed immediately down from where the well is. It is the Seigler Creek headwaters that runs into the historical Seigler Springs Resort, which is owned by Holy Domains. So for you to fulfill your responsibility, you've got to have the right information. And I don't believe the hydrology report or the applicant is actually giving you that. Thank you.
Thank you.
Hi. Thank you, Council. Hi, Trish. I just wanted to say I'm Brian Pensack, one of the principals of the project. Can we get our attorney on? Because I'd like him to address the opposing attorney's comments before everybody kind of forgets about what he was talking about, and I think it's relevant. He's on Zoom.
Sure.
Thank you.
Okay, can everybody hear me?
Yes, sir, you have 3 minutes.
Okay, and I am part of the applicant team, so if there are additional questions, then I assume that the allowance for additional time would apply here as well.
Yes.
Yeah, my name is Brad Johnson. I'm a land use attorney, land use and environmental attorney. I've worked on a number of projects in Lake County and around the state, similar to this one. I listened to the attorney's comments regarding the access easement. I think it'd be helpful just to run through the basic facts, since I think one of the commissioners had called into question what those facts were and commented that they were somewhat confusing. So I'll just run through them very quickly here. So the access easement that benefits the project site was created and signed and granted by James Philip Garras, I'm not sure how you pronounce his last name, in October of 1993. But earlier that year, in January of 1993, James conveyed all of his interests in the property that's now owned by Holy Domains and that would be burdened by the easement to Lucille Garras. So that happened in January 1993. Then that same conveyance was re-recorded in April 1993. That was to correct the notarial acknowledgement. It wasn't a new conveyance, it was a correction. And then lastly, in February of 1994, Lucille reconveyed the property back to James. So what we have is James conveyed the property to Lucille in January 1993. Then in October 1993, James granted the easement. And then in February 1994, Lucille granted the property back to James. And these facts are all acknowledged in the attorney's letter. But the important information here is that Lucille conveyed the easement or conveyed the property back to James in 1994. So as a general matter, the attorney is right. You can't create an easement over property that you don't own or control. That's a basic proposition. I don't think we need to dive into that any further. But what the attorney forgot to mention or failed to mention or wasn't aware of is that there's a very long-standing legal doctrine in California called the doctrine of after acquired title. And this doctrine exists both statutorily and it also exists in common law. And the two are not the same, but they do overlap. And what we're dealing with here is the common law application of the doctrine of after acquired title. It's best explained in a case called Nerona v. Stewart. And I attached a copy of that case to our comment letter. That case was decided in 1988. It is still the leading case on this issue in California. In fact, it's cited in other states as well. But the way that the court describes this doctrine is this, and I'm quoting directly from the case. The general rule is that if the grantor in a conveyance of real property has no title, a defective title, or an estate less than that which he assumed to grant, but subsequently he acquires the title or estate he purported to convey or perfects his title, the after acquired or perfected title will inure to the grantee or his successors by way of estoppel. So what that means is, even though James did not own the property when he created the easement, because he gained ownership of the property or regained ownership of the property subsequently in 1994, his ownership of the property became perfected and the easement became perfected as well. So that is a matter of case law. It's long established in California, and that's exactly it exactly applies in cases like this, where we have this after acquired title circumstance arise. So these things don't appear on title. There is no case or statute suggesting that if something doesn't appear on a title report, then it doesn't exist. That's just not a legal reality. So the fact that it doesn't appear on a title report is irrelevant. I think one thing that I think Tim emphasized here is the Planning Commission's role, yes, is to decide whether it can make all the required findings for this project. In this circumstance, title documents have been provided demonstrating the very facts that I have discussed with you here. And case law applies to this circumstance and holds that the easement is valid. So as far as access goes, there really is no legal question. And I'm happy to answer any questions.
I have a question for Mr. Johnson.
We're going to go to the next person that wishes to speak. Then we can bring it back for further questions.
Hi, Dr. Janine Pfeiffer. I'm an ethnoecologist. I work for Lake County as a consultant with the Water Resources Department. I also work for Big Valley, Band of Pomo Indians, EPA, and Tribal Historic Preservation Officer, and with the Cobb Watershed Education and Resource and Restoration Program. My comments will refer to integrity, and integrity on three fronts: ecological, economic, and sociocultural. Ecologically, as we all know, the county is under an emergency order to protect the hitch. The hitch is why we have the Cobb Watershed Education Restoration Program, and we're working with private landowners to help restore hitch-bearing streams. As far as we know, according to Sarah Ryan over at Big Valley Band of Pomo Indians, there are no water gauges on Ziegler Springs. So we do not yet know the impact of additional water withdrawals on Coal Creek, but we can only assume that it will not be a positive impact because, and this brings me to my second point, economic integrity. There is no way that this grow will be sustainable at 2,000 plants per acre. Can't do it. Indoor grows tend to plant more than outdoor grows, and the average number of grows per acre is anywhere from at least 1,200 up to 5,800. My background is in agronomy from UC Davis. So to begin with, a misrepresentation concerns me because all the other science data statistics are based on that. Thirdly, sociocultural impacts. To my knowledge, there has been no tribal consultation. The Wintun tribe was approached. They were told to consult with Ron Montez Sr., who is here in the audience, and he can speak to whether or not that consultation took place. But also, it concerns me that a former speaker referred to the high number of comments as an organized effort and portrayed it negatively. And I'd like to flip that. I'd like to think here in Lake County, we care about our communities and that we care about our neighbors. And are we being good neighbors, or are we basically giving the middle finger to the people who live around us? So that's my concern. Thank you for listening, and I have a dental appointment.
Does anybody else wish to speak from the chambers? Please state your first and last name for the record, please.
My name is Indigo Perry. I'm a resident of the Loch Lomond area. I've lived up here for decades. When I first got back up here after the Valley Fire, when there was finally housing available, I finally found a place to rent, and I was so happy to get back up here. But then I discovered that there was a brand new grow operation, really literally steps away from me. And the thing that, it wasn't a moral issue, it was the level of threat that I felt 24/7. There were always people patrolling with dogs. There was a very unfriendly attitude. In other words, they weren't here to be good neighbors here in Lake County. They were simply here for a business operation. the sound of generators constantly 24/7, the sound of ATVs constantly. It was a disturbance in a place where I have lived peacefully for decades. And so those are just some of the reasons why I oppose this operation. Thank you.
Ma'am, are you saying that the current applicant was causing?
No. It was
Well,
not the current applicant.
Right, I'm
at
not
all.
sure that that has anything to do with this particular issue.
Just having lived in an area where there was a grow
I
operation
appreciate
close
that.
by.
Sure.
My name is Magdalena Valderrama. I'm the program director for the Siegler Springs Community Redevelopment Association. And I also helped to found the Cobb Area Council. And I'm mentioning that only because when we did that, we found out that the Cobb Mountain Area Plan has not been updated since 1989. And so I'd just like to remind your commission that I realize that all of the arguments that are being put forth in favor of this project are still based on a very old plan, and that stuff that has not taken into account the environmental damages that have occurred from the Valley Fire. I also want to state that as the program director of the Siegler Springs Community Redevelopment Association, we are the lead agency for the Cobb Watershed Education and Restoration Program that Dr. Pfeiffer mentioned. She misspoke referring to Coal Creek, but the headwaters are for Siegler Creek, and Siegler Creek is that hitch-bearing creek that feeds right into Clear Lake. So there is a concern that we have, just even based on the work that we have been doing in this past year, for that matter to be addressed. And so that means that there are cumulative impacts that have not yet been addressed. I would also like to, I don't know what the pesticide regulations are, or what kind of pesticides the applicant will be using or anything, but I'll just note that cannabis doesn't use registered pesticides because there are no registered pesticides for cannabis crops. So you know, if you don't have the standard, then you don't have any standard to meet. So there still is a concern in that regard. I'll stop there. Thank you.
Thank you. Do we have another speaker from the chambers that wishes to speak?
Good afternoon, Commissioners. My name is Elliot Hurwitz, and I'm the Executive Director of the Siegler Springs Community Redevelopment Association. And I also want to speak to the concern that we have about the both not just the quality, but the quantity of flows in creeks in in the watershed that's centered in the Cobb area, including Siegler Creek. Just correct, I mean, Siegler Creek does not flow directly into Clear Lake, but it does flow into Cache Creek just below the lake, and it is a significant hitch-bearing creek. And we've been working through this, the Watershed Education and Restoration Program with property owners.
Testing.
Check. Check, check.
Check, check.
Oh, yeah, mine's on.
All right. If we could please be seated, we will start our meeting. It is 10:34. So we left off at public input for the project. So if anybody in the chambers wishes to speak, please approach the podium and state your first and last name.
My name is John Salek. I've been a homeowner in the area for decades. I have in recent years become greatly concerned about the water issues and talked with a number of my neighbors about will we be able to continue living here with droughts and climate change making things worse. But that's not really what I stood up to talk about. There are people that know far more about that than me that have spoken. What I want to speak about is safety. I walk in an area fairly close to this new grow operation, an area that has a grow operation and has security cameras and has guards and signs. So
Hello, hello.
Check.
Check.
Good? Okay. Hi, good morning. My name is Sally Schumacher. I live about a mile from the proposed project. And I walk almost every day on the road that goes right by where their access road would be. It's one of the few places within driving distance where you can walk on relatively level ground. And at 80, I need level ground. But it's also really wonderful because it's very quiet. There's very few cars. There's lots of people who walk there every day. And just on a personal note, I would really hate to lose that as a result of this project with all kinds of trucks and who knows what going up and down. It's a really special place that I valued over the years. Thank you.
Thank you.
Good morning, everyone. My name is Walter Musinski. I'm the CEO of the Holy Domains that owns the property at the Mountain of Attention. After the Valley Fire, the people who owned this particular parcel that the easement is supposed to go through, who were members of the community, were forced to sell the property. And they had intended to donate the property to the sanctuary, which is an agreement with our spiritual master that they made a number of years ago. We found out that there was going to be people who were going to purchase that property as a grow, as a marijuana cannabis grow. And we were able to secure funds to buy that property, so to stop a grow. And as other people have said, a project like this tends to bring the kind of people into that area that could cause problems. Two people talked about security, and these things will affect the sacred nature of this whole area. It's not just a sacred area of the Mountain of Attention, but this has been sacred land for the Native people for decades, centuries and centuries, and we want to preserve that. That's all I have to say.
Thank you for your comment.
Yeah, he's going to let me share a little diagram real quick about to show some well locations. My name is Alex Powell. Good morning. Walter's my associate. I'm the CFO of the Holy Domains. And, okay. One moment. Thank you. I did. Okay, share. And then do a share screen. Okay. Forgive me, I haven't done this before. Okay. Just to let you, to refer to the diagram here, 1 and 2 are the lots of the applicant. And we just wanted to point out that the well, one of our primary wells is the one in the red box there, much, much closer than the mile. It's actually just below it. And the asterisk and the X above are 2 other wells on our property that are active. The one above is actually at our retreat facility. And I happen to stay there actually each week when I come up. I live in Santa Rosa, but I come up and stay 3 days a week. And the other thing I wanted to say was just to make clear that it seems like the headlands of the creek are in the applicant's parcels or in that general area. That creek flows directly through our primary sanctuary, which isn't on this map. But I wanted to just make that point about the water and the potential effect that a large grow could have. We did have, just last year for the first time, as I understand in the history, we had wells go dry. We were not getting water consistently anymore for literally the first time. So we had to do some conservation measures. And then, of course, we had the big rains last year, so we got out of that. But so it's just it's a big deal. And I think some further studies are absolutely, required for something like this. The only other thing I wanted to say is that I stay in the, like I say, the retreat center. And we have many retreats, including for youth and children. And just above that is a current grow with only 4 hoop houses. And I mean, even last night I come home and it's just the pervasive smell and the noise is pretty intense. And especially when you're living in a contemplative life that, and maintaining a contemplative space of the sanctuary, it's kind of intense to have to deal with that on a day in and day out. Every time I'm up here, I have to deal with the smell. I can't even open up. And the noise too. There's this like refrigerator in your room kind of noise can be, it's not all the time, but it's consistent. And even at night, like there are beautiful days up here where I can't open up because that hum is a little too intense. So I just wanted to kind of mention that as an immediate effect of something. And it's not the grow, but this is just across the road. And it's only 4 hoop houses. Also, when you come into this property, that's the first thing you see. It's intense to kind of come to this beautiful nature, this beautiful land, and then bam, these hoop houses stand out. They're on top of the hill. And it's only 4. And so most of the grows that were referred to are kind of over the hill and further north, and you can't see them. But that one is imposing, and this one would be incredibly imposing, and a lot more. So anyway, that's all I had to say. Thank you.
Thank you. Anybody in the chambers wishes to speak?
Good morning. My name is Larry Rugoff. I'm the forest manager for Holy Domains. Since the Valley Fire, there's been 3 archaeological studies done bordering this site. Each time it's gotten greatly enlarged. At this point, we're working with Clear Lake Environmental Research Center called CLERC, because we have a grant from CAL FIRE to reforest the area that got burnt in the Valley Fire. It ends up that the archaeological site has gotten greatly, greatly enlarged to the point where it now it goes into the applicant's site. And this was a major archaeological, this is a major archaeological site for Northern California. It had over 100 full-time residents. The name of the site was Pakut, and there's no study that I can see. I mean, this is a major archaeological site in Northern California. And again, the new archaeological study that was just completed actually goes into their site, and it shows also satellite sites in their property. So please take that into consideration. Thank you.
Thank you for your comment.
Good morning. I'm William Stranger. I'm the closest resident to the proposed cannabis grow. I live literally right on the corner of that map you were just shown. The founder and publisher of Dharma Cafe Books, dharmacafe.com. I'm a member of the church that owns that property. I believe in the report that you got about the proximity of the core sanctuary to the property was somewhat mistaken, as if all the activity of the sanctuary is 1.3 miles away. Actually, the sanctuary itself has something like a dozen temples and holy sites on it, that core area, but there are two literally right across the street from the grow. Several years ago, my colleague Elliot Hurwitz and I went and visited the owner of the property. This was many years ago. He lived outside of Kelseyville, and when we got to his home, his living room, you couldn't ignore the fact that it was filled with Nazi memorabilia. And I think we didn't look sufficiently Aryan when we suggested we'd like to get that property and put it aside, because we told him it was, for us, a sacred land that overlooked this great sanctuary, and we wanted to see if it could be set aside in perpetuity. It actually overlooks a sanctuary that serves hundreds of people, members of our church here in Lake County. They come here specifically to go there daily. Every temple there is served daily. People pilgrimage from around the world to come to that sanctuary for long-term meditation retreats. And what Alex Powell just told you about the property is absolutely true. We live right across the street from those 4 hoop houses. Sometimes the lights are on at night. There's often fans. The noise can be interminable. The smell can be terrible. We have to close our windows sometimes on summer nights or winter nights. We've noticed that our wells water has dropped precipitously since they started growing there. As Margaret was mentioning about the walks, many people come and walk. Members of our church and other people walk the area because the road is safe, it's calm. And for us, this is a great and profound holy site. It's not just the land set aside for quiet. It's a place that is imbued by the Spirit of the divine. That's why we're here. And it is a place we believe is not only a benefit to members of our church, but to everyone. It is a place where our own membership regularly gathers to pray for the sake of the world. For the last 2 weeks, I've been working day and night, invoking the divine to prevent this global war from breaking out in the Middle East. I work with people in peace all over the world on this, dealing with political candidates and other methods of how we can do this. They have come to our sanctuary for spiritual refreshment and then spoken of our teacher as a being of great spiritual power. And it is, we've published a book on this. But it also has benefited Lake County in remarkable ways. And one was during the Mendo Complex fire. The fire, you may remember, came to the very north of Lucerne and Nice, and was at the top of the hill there. It was threatening to sweep down to the lake. My wife and I, to get away from the smoke, went over to camp at the coast, but we felt like we were really concerned about this fire. So I called Elizabeth Larson of Lake County News. I said, she lives in Lucerne. I said, what's happening there, Elizabeth? She said, we're really worried. I just spoke with CAL FIRE, and they said they don't think they can control it. The winds are chaotic at the top of the hill. It could break down and sweep down and take out the whole North Shore. What do you need? She went, what do you mean what you need? I said, tell me what you want to have happen. She said, well, what they said is the winds have to die down. It has to go. Well, then I said something rash overcame me. I said, well, you don't know much about me, but I'm a member of a church that has a great prayer sanctuary here in Lake County. I've never told you this before. And we do specific prayers to intervene in things like this. So I'm going to contact the priests of our sanctuary, and I'm going to have them go to work so that the results you want comes about. The next day, I got a text message from Elizabeth, and I photographed my cell phone before erasing the message, and here's what she wrote me. Bill, I think we had our miracle. The wind shifted and pushed the fire up away from Lucerne's castle. Today's CAL FIRE update explained that they had had several bad days in the fire lines with nothing working, and then suddenly things started to go right. So thank you for what you did yesterday, for the phone call, for the encouragement, for the prayers and the intervention of the priests. The winds are accessible, just like you said, and that opens up for me a new vista of possibilities. I've been working to create a college here that will allow sacred views and secular views to be combined. The laws and
Excuse me, sir, the 3 minutes are up. If you would like to wrap up your comment.
I urge you to consider the fact, I haven't even talked about the deer population repopulating. They sleep on that property at night. I watch them. They, the animals, the lands, the creatures of this county, they're all part of this county. I'm a voice for them, for the sacred. And this is really, this area is a resource for all of this county, even this country. And I urge you to protect it. That mountaintop is the northern sentinel protecting the sanctuary's repose. It would be a disaster for the sacred incarnation in this county for this grow to be permitted. And I ask this man who's a chiropractor to consider, since the chiropractic has also been an oppressed discipline in our country because they allow for life moving, to consider making this a donation, this land a donation to our church. We would promise to protect it and put it aside in perpetuity. So thank you all very much.
Thank you.
Duenami Kodie means good morning in Batsal, Eastern Pomo language. That's where we are, and this area is our traditional homelands. But
excuse me, sir, I don't want to interrupt. Could you please say your first and last name?
First name, Ron Montez, Big Valley Band of Pomo Indians. I'm a tribal elder and also the Tribal Historic Preservation Officer. I wear many hats and I have a lot of responsibilities. One of them is our traditional Aboriginal territories that we, in our past, we relied upon for our livelihood, our food sources, and everything that was important to us to sustain our community and our life. And so we traveled. We were not farmers. We didn't plant seeds. We went where they already were planted because that's where Creator put them. So we'd go when the seasons came and we'd gather. When it's time for rabbits, we know where they are in these different valleys and ravines and different places. We go there and we hunt our rabbits. Those furs make into a big shawl like a blanket. We knew at different times when the grasshoppers were supposed to be here, and then they would cause a fire and gather them all up in the middle of the fire. They'd be all toasted, and you could crunch them. It was a food source. We were familiar with this whole land, and we camped all over. And when our elders passed, they were buried there, and so those places became a sacred place to us. Most of those places have not been uncovered yet because we were everywhere. And so there's a potential out there because I was out on the properties next to them where there is a site. I and the Tipo from Middletown, Mike Rivera, went and visited it, and we felt that presence of our ancestors. We could see with our eyes the water course that would come down and see where the different plants were, and we could tell just by looking at those where they would be gathering, sedge and stuff from off the sides of the banks, and also where they'd be pulling and gathering and collecting willow for the baskets. And also that there would be crawfish and other little fish in it that they would live off of. And where that water course went down into another water course on the other side of the road. And so we take these opportunities to come back to our traditional lands because we were never allowed to. And so when we get there, we have that sense and we pray and we recognize all those trees and all those animals that are there and that are coming back. We have what we call in our ceremonial regalia, yellow hammer, which is a bird, a flicker that has orange and black feathers. And you'll see them in our regalia. They're back there, and I haven't seen them for a long time. And when I seen those things again, it reminds me that my ancestors are still here in that place. And so I talked to them. I apologize for taking so long to come back and acknowledge them. I acknowledge the trees that they maintained for their food and the animals that are there now that provided their life. And that whole area on that road, North Ziegler Road, it goes out, that whole area in there, I've driven it, and I sense that I'm back home amongst my people. And that is something that's sacred to me and to tribal people, being back, which we have been forbidden to for many, many years. And this area where this grove is going in will make an impact, a negative impact upon all those, my relatives out there, the animals and the birds, fish in the water, and the trees. And there may be even some excavation going on that you might come across some of artifacts or even some bones that belong to my great-great-great-great-grandfathers. So I would encourage you to think real hard about the impact that this would have upon not only the community, but upon my relatives who still live there. Thank you. Thank you for your time.
Thank you. Yeah, anybody in the chambers wishes to speak, please approach the podium. I want to get people that we haven't spoken yet. Please state your first and last name for the record.
My name is Matthew Spence. I live in the area, have off and on for many years. Someone earlier in the session referred to cannabis as an agricultural activity, like other agricultural activities. I think, let's be honest about this. This is not agricultural activity. We're talking about an industrial installation. We're talking about a grow operation. It's going to have profound impacts on the water, the environment. People talk about it is of such significant economic and physical activity that it requires security. It's going to dramatically change the whole character of the neighborhood. Absolutely. I don't know what the zoning laws are, but in terms of land use, you put an we're putting a factory in the middle of a residential area, not just residential, it's not even rural, it's wild. And I think that it's going to dramatically change. It would change everything. So in terms of land use, it's just totally inconsistent with everything else that's happening in that part of Lake County. And everyone, and the reason everyone, an entire community of people is there. I think it just doesn't belong in this environment. I really encourage you to really seriously consider the advisability of this project. It doesn't work with what is already there and the people who live there and the lives we've created. Thank you very much.
Thank you for your comment. Please state your first and last name for the record.
My name is Steve Reed, and I'm a landowner. I own what was formerly Bonanza Springs Resort, and I'm amazed at the amount of information that I'm getting here today about all the various aspects of the property that is being discussed, especially the sacred nature of it, the environmental impact of it, the industrial impact of it. I'm blown out, and my main concern was water. I don't want to have to drill a deeper well on my property if this operation takes water for a business when I need it for my own personal use. And I have experienced the drought making a big change on the water table on my property. I have discussed this with geologists, and it's very difficult to determine where the water is coming from and where the water is going and how fast it's getting refreshed. It is very certain that this operation will take a lot of water. And I've heard that the amount of cannabis being grown is somewhat in question, and I'd certainly address that very seriously so that everyone is aware of how much it's going to take and what kind of impact it will have on all of the other residents downstream from that operation. Thank you very much.
Thank you for your comment. Anybody else in the chambers wishes to speak? We'll take a look at the Zoom room, see if there's any hands in there.
No one is wishing to speak in the Zoom room.
Angie Dodd wants to comment.
Ms. Dodd, you're available to speak.
Oh, yes, I was waiting till I don't know if I accidentally raised my hand. I was gonna wait until all online comments were done and speak at the end after Richard, if that's possible. Or did you want to ask me questions now?
You can go ahead and proceed.
Okay, I think I wanted to follow Richard to see what he ended up with, and I can follow his comments. Unless you have specific questions for me now.
All right, we're going to take another hand in the Zoom room.
Participant Mark, you are now allowed to speak. Please state your first and last name.
Hi, Mark. Could you hear us? You've been unmuted. If you wish to speak.
Yes, can you hear me?
Hi, yes, we can hear you.
Yes, can you hear me? Okay. My name is Mark Travis, and I live about a mile away on North Ziegler Road, and I'm concerned about traffic, as we already have had to deal with semi-trucks and other delivery trucks bringing materials, fertilizer, et cetera, on the road here, and it's definitely impacted us. I did want to mention that nobody's mentioned the number of workers stated in the application. They said 3 at peak season,
And I find that hard to believe as a large operation as they're proposing, that number would be a minimum 3 times as much. And that's all I have to mention there. Thank you.
Thank you. So I am going to bring it back to the chambers for further discussion.
Hello, thank you again. I would just like to speak on the easement issue again because it has become quite confusing. However, the applicant,
first and last name?
George MacDonald, attorney for Holy Domains. The applicant, through its attorney, did make an important concession. The easement on its face is invalid. So the easement should be viewed in that light. It's invalid on its face. Now, the applicant may very well file a court case, get a judge to order that the after-acquired title doctrine applies to this and get a judgment and then record that, but that hasn't happened. And also, the after-acquired title doctrine does not always just apply. It's based on estoppel. Estoppel is justifiable and reasonable reliance. It usually only applies when the property has been improved, has been developed based on reliance of the easement. That hasn't happened. It's a vacant lot. There's been no reliance whatsoever on it. And also, that case that was cited by counsel was in 1988. There's been a lot more case law since then that has chipped away at the common law doctrine. The statutory doctrine does not apply. The statutory doctrine only applies to fee simple conveyances, not easements per se. And now, the more recent case law finds that where the new owner of this property didn't know about the easement, right, wasn't in their title report, for example, it may not apply. They can't be bound by it. It's an equitable doctrine, balance of hardships. Who's going to have the hardship here? Who knew what? Who did what at the time? It's a highly evidentiary analysis. So we start from the base. The easement's invalid on its face. They certainly have the opportunity to get a judge to say the grantor, now Holy Domains, is stopped from denying it, but that hasn't happened yet. And that's what would be required to find that this is a valid easement. Thank you.
Thank you. Seeing as there's no more hands or people wishing to speak, I will close public comment and bring it back to the commission.
Well, she was waiting for Richard. Is Richard going to be speaking, or?
Mr. Chair and Planning Commissioners, I guess the question at this point is what the commission is going to do, of course. I think what the applicant would like to request is a continuance to a date certain so that we can address the myriad issues that have been raised, provide the information that the Planning Commission has requested, clarify what we believe needs to be clarified. I assume that's where the Planning Commission might be going, but we'd like to request that at this stage. We don't want to be denied on a project where the full scope of details and information has not been provided to the commission.
Were there further questions or comments from the other person on Zoom?
Can you guys hear me? This is Angie Dodd from North Point Consulting.
Yeah, we can hear you.
Yeah, I can respond to, so what I would respond to is the comments regarding water. I can respond to them now, or I guess I'll just go ahead and respond to them now. I have a list of items that were brought up. First of all was the number of plants per acre. The other way to represent that is the typical range in water use per per plant. We usually represent that as gallons per square foot, depending on the size of the plant. So when plants are smaller, it's about 8 gallons per square foot. You have larger plants, about 15,000, not 15,000, excuse me, 15 gallons per square foot. If you do that over 4 acres of canopy, that range then is 2,000 to 3,600 gallons per day per acre, which is in line with the volume of demand represented in the hydrology report. And it was demonstrated that over the parcel acreage only, their fair share of recharge would more than support that demand over a year using a 180-day cultivation season. There were comments brought up about the type of cultivation. This is an outdoor cultivation project. It's not an indoor cultivation project. There's light deprivation is a possibility, but there's no light assist. The only lights that would be on this property would be security lights, and those would be solar operated, and they would be motion censored lights. So I just wanted, in terms of the activity, indoor, mixed light, all those have been brought up. And that is not how this cultivation is being proposed. Talking about impacts, the well's impact to the surrounding hydrology. The well is drilled to a depth of 440 feet into shale and sandstone below the layer that wouldn't affect surface water. We call that hydrologically disconnected. So the well is hydrologically disconnected from the surface water of Sigler Creek, or I think it was Coal Creek that was brought up. The Holy Domain wells were brought up. Both of those wells are over a half a mile away from the project well. And the wells, at least the well that's in the little square parcel that was mentioned, is drilled likely well below the project parcel well, but again, half a mile away. There could be discussion between the applicant and the Holy Domain group, and maybe a well test could be conducted on the site. And they have a monitor on their well because they are part of a drinking water system, and they can monitor to see if there is an impact when the well is tested on the project site. So that is something that could be discussed to see truly if there is an impact rather than hypothesizing. There was a comment, this isn't water, but there was a comment regarding where the cultivation is located in reference to the Holy Domain parcel boundary. They're 1,000 feet away. The siting of the cultivation is based on that 1,000-foot setback that is no longer, or that setback from a water system, which is their water system, that is no longer in play. But that is why the cultivation is located in the northwestern corner of the project boundaries, so that it is as far away as it can be, and it's over the 1,000 feet as required by ordinance. The rainfall required to recharge the parcel's fair share of water that recharges into that hydrologically disconnected aquifer, even if you assume 1.5 times the demand, you would need 14.7 inches of annual rainfall. The only time, according to the PRISM record from 1895 to 2022, the only time on record that rainfall fell below that amount was in 2013, and last year's rainfall was even more than that on that record. There were concerns. Last year was an extreme drought, and throughout the county we know that folks had issues with water and their wells. That is why the county has implemented the ordinance requiring that all cultivators prepare a drought management plan to demonstrate what they're going to do in extreme droughts. And one of those operational measures is if there is lack of water, then cultivation will be decreased, or there will need to be other legal avenues for water. Things that the project does add to the area is adds additional water storage. The county requires dedicated fire water storage, which is additional water that would be available to firefighters in case of a fire. The cultivation area total is about 4.5 acres. That's only 5% of the entire property. So the remaining 80 acres would be undeveloped and left alone according to the cultivation area amount. So I just wanted to address all those items. I could answer more questions, and I'm available if that is the case. Thank you.
Thank you. Seeing as if anybody in the chambers wishes to speak, we'll double check the Zoom room.
There are no hands raised in the Zoom room.
Seeing no hands in the Zoom room, we will close public comment and bring it back to the commission.
Commissioners?
Yes.
If I can just clarify something. Earlier, there was a mention of Part H in Article 27, and I wanted to provide you with the actual citation for that. It would be Article 27, Part 27.13, parenthetical AT, Romanet 2H3, and that is the section under the major and minor use criteria for cannabis permits that requires a background check. And it does, in fact, prohibit a person with a certain criminal background to have a permit, but it also provides exceptions related to findings made by the sheriff's department, which would be in the background check.
Thank you. So I feel like we kind of sense a consensus on continuing this item because there is a lot of items that are that need to be a lot of questions that need to be answered and discussed among both parties. In order for us to make a clear decision on where this project is headed, relating to the well impacts to the neighboring wells, we have to figure out exactly what's going on there. This is all new information that was brought at this meeting. The setbacks and how they would apply if, in fact, the neighboring properties to the east and south of the proposed cannabis cultivation, how that's going to be dealt with, obviously, between the applicant and the church. Also, you guys have to figure out the whole easement situation for us to make a determination as well. I would like to see a site plan with and without, we already have the one without hoop houses, but one with, and how that was going to look. And we weren't able to see the tree mitigation plan. And it's all information that I think that we need to make a determination on this item. So I guess I'm...
Mr. Chair?
Sure.
If motion to continue is made, I would support it. And if it were to pass, I would encourage the applicants and the opponents of this process to communicate and use that time before the next hearing to perhaps clarify some concerns internally, things that we cannot require you to do but need to be resolved. So I would ask that you make a concerted effort to, in fact, communicate.
And also, real quickly, if in fact the date certain, if we move forward with a continuation, if it will be enough time for all these questions and all this information to be gathered and brought back, because I wouldn't want to continue it again. So I guess
we have just one meeting in November and one meeting in December.
Okay.
Our next meeting would be November 9th, I think, and that agenda is open.
Okay.
I'd like to express that I agree with both my colleagues. In addition, I don't think that the archaeology has been addressed. I believe I read in the packet that 2 of the tribes had been consulted, and they both said that
no,
it wasn't their territory. So.
I'm sorry. We actually sent out an AB 52 notice on November 8th of 2022 to 11 tribes.
Wow.
And out of those 11 tribes, we did not get any requests for an AB 52 consultation.
Okay, well, what I've heard today is that there are some issues, so I'm not able to support this project until that is explored as well. In addition, I'm not going to repeat everything. I'm open to a continuance if there's consensus on that. I'm not optimistic that anyone's going to convince me that it's not an incompatible use from what we've seen today. Those are my comments.
Also, so the dates for the next meetings is November 9th and December 14th? Okay, so we have those two meeting dates available. I guess the question would be to determine if December 9th or November 9th would be a adequate time for all that information to be gathered and the dialogue to take place to mitigate all these issues. Or the December 14th. So I guess I'm kind of looking to see what the applicants or the church think would be a better date in order for us to set a date certain.
14th is fine for us.
Okay, so
Mr. McDonald, does the 14th work?
December? Sorry. Well, I doubt the easement issue will be resolved by then, quite frankly. It's a complex issue. It's invalid on its face. I think the burden's on the applicant to get a judge to order it valid.
Just asking if you think there's time in general to.
No.
Well, then we'd like to deal with it before next year.
Yeah. I mean, I'm just saying, I don't think the issue will be resolved by then. But December 14th, the actual date, I suppose would work as far as availability goes.
So I have a question for County Council real quick. Regarding the AB 52 notice that was sent out by staff, if there was no response, is the applicant required to send out another, or the county to send out another notice, or has that window closed?
So the applicant is not the entity that handles AB 52 consultations. It's the lead agency, and the lead agency sends it out at the beginning of CEQA review. So if they're not redoing CEQA review, there would not be need for another AB 52 consultation. However, staff could reach out again if they choose to do so. There is nothing that prevents that. It's just CEQA does not require it.
Okay, thank you. And that would probably be a caveat to the applicant from my perspective. There are a number of issues and questions that may be answered in the coming, the next certain date. But I would request of the applicant to consider to do that, to reopen. We did hear from the Tribal Historic Preservation Officer from Big Valley. If Middletown Rancheria was on site, then there is interest, and I would just ask that that be considered among some of the other questions that are being asked.
public comment has been closed. So
Mr. Chair, I'm just trying to, sort of a point of order here, trying to respond to the question about continuing. So, don't know if you'd like some input from.
well, yeah, if it's going to be pertaining to that question, sure. I would like to hear that.
The question is whether or not to continue the matter to a date certain or indefinitely at this stage. Given the information and the issues, it makes sense for the applicant to continue indefinitely, which means the county would need to renotice when the matter comes, is scheduled and comes back to the commission.
So to a date uncertain.
That works for me. I mean, earlier today you said you wanted a date certain, so we were trying to accommodate.
Right, yeah. We just talked about it. There's some concern about being able to get everything put together.
Fair enough.
Okay, I guess I'm looking for a motion.
Mr. Chair, I move that this agenda item be continued to an unspecified date in the future.
I'll second that.
All in favor?
Aye.
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 All opposed? Item is moved.
Thank you.
Thank you. I'll just wait for people to exit the room before we take on our next items. All right, non-timed items, don't see anything there. Department update.
Thank you. Just so the commission is aware, as we've been going back into virus season, yes.
Gentlemen,
Can we?
gentlemen, could you take your conversations out of the, we're still conducting business.
Thank you. Just for the Planning Commission's awareness, we have the three different divisions have pivoted back towards more of a remote working environment in order to maintain the health of the most of our staff as possible. So, but we still remain available. Should the commission have any questions, concerns, issues, feel free to contact me. And a little bit of good news, we extended an offer and it was accepted for a principal planner. Woohoo! And so I will have more information about this totally amazing person that's about to join our team soon. And that concludes my report. Thank you.
Commissioners, I do have one thing. I'd like to introduce Joseph Wankmueller. He's the newest addition to our office. You know, since we all fill in for each other, I thought you should know him. We're a little behind. He's about 3 months in, but better late than never.
And meeting adjourned at 11:30.